Mr. Trumpeter.
My lords, my lady. So we've just gone through those two cases, and it then finally falls to be considered how do you apply principles in those cases to the facts of this particular case. And once you've understood the principles properly, actually the application is very, very straightforward. This is a classic Class 2 trust scenario. Indeed, one can see that. Just briefly, one turns up my learned friend's skeleton argument at paragraph 84.3. What is said there is that Mr. Conway breached his duties to South Bank by positively permitting or by failing to prevent a related company to grant a lease. Okay. So, taking that on its face, all that can be said is that Mr. Conway, as a director of South Bank, permitted or failed to prevent a different company from granting a lease. Now, if that's right, what it means is really no more than Mr. Conway is an accessory to a breach of trust committed by Galliard Hotels. And perhaps most importantly, what Mr. Conway, with his South Bank director hat on, or as Lord Justice Patton might say, virtute officii, if one is allowed to use Latin anymore, I'm not sure, but with that hat on, Mr. Conway has no proprietary relationship with the lease, other than as a recipient of the proceeds of what South Bank alleges is his breach of duty. That is classic Class 2 trust territory. And the reason I say that is because the reason I say that Mr. Conway's liability arises directly out of the lease transaction itself, which is a really important point to appreciate. The liability arises out of the lease transaction itself. And the reason for that is, I suppose, twofold. First of all, as I've already indicated, South Bank doesn't allege that the lease is or represents proceeds of trust for the purposes of Section 21(1)(b). So it's something separate from that. But moreover, it is not a transaction which, as a matter of law, Mr. Conway could have entered into by virtue of his office as a director of South Bank. And that's because, first of all, South Bank has no legal title to the freehold at the time the lease and the underlease are granted. That is vested in the Galliard Hotels. And also, if I'm right about the nature of the right that South Bank had at the time when the lease and the underlease were granted, following the Southern Buyers case, Mr. Conway, as controller of South Bank, couldn't have granted proprietary rights to a third party, at least not until such time as the contract had completed, which it hadn't in 2008. So what you're left with then is a position that, just like with Mr. Koshy in the Gwemby case, South Bank's cause of action, and just pausing there, one has to always bear in mind we're concerned here with causes of action, so you can almost, in an abstract sense, imagine what the pleaded cause of action against Mr. Conway alone might be. That cause of action is not dependent on establishing that he had received any property belonging to South Bank. Rather, again, just like in Koshy, its cause of action is based on what is said to be equitable disabilities or fiduciary duties to which Mr. Conway was subject as a director of South Bank. And that's quite distinct from the responsibility borne by Galliard Hotels, or Mr. Conway as its director, to comply with the trust obligations imposed by the freehold sale contract of the type described by Mr. Justice Lawrence Collins in the Engelhardt case, where he describes the trust obligations. Those are separate. There may well be, the judge didn't decide, there may well be a breach of those trust obligations or trust duties. But that is independent of and unrelated to anything that Mr. Conway received with his South Bank hat on. And so once one appreciates those very simple, albeit perhaps slightly nuanced distinctions between the different entities involved, this is exactly like the Grenby case. And according to Grenby, there was equally two companies effectively owned and controlled, at least one I think the lender was owned and controlled by Mr. Koshy, the borrower wasn't owned, but it was controlled by Mr. Koshy. But it's the same point. In that case, as a director of the borrowing company, he made an unauthorised profit, but it was unrelated to his responsibility for the property that Mr. Koshy had assumed by virtue of his office as a director of that company. So I think that's, if I'm right on that, then we are not in section 21(1)(b) territory at all, and this is just a standard section 21(3) case. So my lords, my ladies, unless I can assist further on that, I'm going to move on. This is now respondents ground 1 little b, which is a point about no conversion to Mr. Conway's use. Now here, what we have is a lease that's granted to a company of which Mr. Conway has a minority indirect interest. And one then has to ask, how is that a conversion to Mr. Conway's use? And what South Bank relies upon are the Burnden decisions. And I think we need to look at both the Court of Appeal and the Supreme Court for this. The Court of Appeal is at tab 41, which is volume 3, please. My learned friend has already taken you to some of the facts of this case, so I'm not going to go back through those again. So, but what I will do is perhaps pick up at page 1021, paragraph 37. In dealing with the submission, in fact, actually, do you know what? To put this into context, I could probably usefully take you back a page. I'm so sorry. Paragraph 34. You see, the point taken at the top of 34 is that the share was never received by the defendants. It was transferred by way of distribution in specie from the company to another company, and then from that company on to yet another company. And there's then some discussion about that, and in that context we get at page 1021, paragraph 37, an observation 3 lines down by Lord Justice Richards that the significance of control of a company is that it enables the controller to obtain in a number of ways the benefit of the assets of the company, or indeed the assets themselves, or their proceeds of sale. And so what I think the Court of Appeal thought was that when you're considering whether or not something has been converted to a director's use, even if the asset ends up in a company, the question is whether essentially there is sufficient control over that company to justify the conclusion that the controller can obtain the benefit of the assets of the company in question. And that is then, I think, broadly reflected in the Supreme Court, which is at tab 45. Ask you please to turn to paragraph 15 on page 1241. and you'll see the submission by Mr. Chivers of sub-Roman 3, where it was said it was
Sorry, I wasn't keeping up. Which paragraph were you?
paragraph 15, page 1241, sub-Roman 3.
Yes.
The submission was, it's wrong in principle to equate control of a company with possession of its assets, save perhaps where the company was a pure nominee. And there was a submission that the majority shareholders had much less than absolute control. And we can see how that's treated at paragraph 60, page 1242, where Lord Briggs thought that the carefully constructed submissions were of real force. And between letters D and E, Lord Briggs said, the submission that control of a company afforded by being a majority shareholder and director is not so absolute to confer de facto possession is persuasive. But taken as a whole, those submissions don't lead to the conclusion that the provision is inapplicable, merely because the misappropriated property has remained legally and beneficially owned by corporate vehicles throughout, rather than becoming vested in law or in equity in the defaulting directors. And there's the conclusion ultimately in paragraph 22. Lord Briggs thought that there was a conversion because of the economic benefit which the shareholders stood to derive from being the majority shareholders in the company for which the distribution was made. Now, in my submission, the key consideration in this context, I think it's reflected in the judge's decision, is whether there is de facto possession. If one goes back to 16, paragraph 16 of the judgment.
Of our judgment.
I'm so sorry, of the Supreme Court judgment.
Okay.
What I think the court is particularly concerned with in this context is whether the level of control that a shareholder has in a company, in a sort of de facto, in a very real sense, gives it ownership of the assets of that company. And in that sense, you might draw an analogy with cases where, for example, a receiver might be appointed by way of equitable execution over, say, a power of revocation. I'm thinking of cases like Tasarruf and Merrill Lynch, where the power of revocation is kind of akin to ownership. And you might want to take I think the courts take a similar type of approach here, where it's recognised that the degree of control that a person has over a company is akin to ownership, such that the conversion ends up being for their use. And if that's the right approach, then one needs to go and have a look at how the judge dealt with this in the core bundle at page 134. And in particular, the finding at paragraph 346. Now, I take on board my learned friend's point that he made yesterday, that the discussion in 346 was raised in a slightly different context as to whether or not the lease should be treated in Mr. Conway's possession. So strictly, this is not actually about whether or not there was a conversion to Mr. Conway's use. But nonetheless, the finding in the latter part of that paragraph is still a finding of fact that hasn't sought to be overturned on appeal and is relevant to the question of control, or to conversion to Mr. Conway's use. Because what the judge found is that Mr. Conway controlled indirectly 47.68% of the shares in Lodgeshine, and he was referred to no evidence suggesting that Mr. Conway was able to control any of the majority. And from that, it might be thought logical to conclude that since the judge didn't see any evidence that Mr Conway was able to control that majority, he couldn't be satisfied that, as a matter of fact, Mr Conway could control Lodgeshine. And if that's right, if he's not a controller or the controller, then it's difficult to see how, following the approach in Burnton, the conversion can be to Mr Conway's use.
Just to understand what's being said there, this reflects the fact, does it, that Mr Conway's direct shareholding was 47.68% in Galliard Holdings Limited?
I think in Galliard Homes, I just need to double check the...
Because on the structure chart we were given this morning, Lodgeshine is 100% owned by Homes, and Homes is 100%
yes, I
owned
think
by
that's right.
Holdings.
Yeah, I think that's right.
So,
yeah. So, by the way, I think that's
right. That the evidence was, sorry, the findings were that the others were held by members of his family through a company incorporated in the Isle of Man. Looking at paragraph 161.
Yeah. Yes, I think that. Yes, that's right. But obviously, that I don't think it was suggested at trial that, and I don't think it's been suggested on appeal that the family ownership element is to be equated with Mr Conway's ownership element. They are separate.
just for completeness, where it says Mr Conway owned 47.68% of the shares in Galliard Homes, that actually means Galliard Holdings, which itself owns Galliard Homes.
I think that's right.
Yeah.
Anyway, that's I think what I would say on that that point.
What, do you have any submission about paragraph 176 of the judgment?
Well, that is evidence given by Mr Conway concerning his control of the board, which is, I think, different from the issue we're concerned with, which is his beneficial interest in the relevant companies. So moving on then, can I pick up now my respondent ground 1 big A, which is the sort of tripartite series of issues: no breach of director's duty, duomatic, and relief. Now, the reason this has been raised really is because at paragraph 433 of the judgment, 149.
Sorry, 149.
433.
433 at page 149 of the bundle. Sorry, 149 of the judgment. So 149 of the bundle. At the end of that paragraph, the judge observed that he had made factual findings so as to enable any question of breach of director's duties and so forth to be determined. And he makes similar observations elsewhere in the judgment. And one might discern from that that the judge thought that if and insofar as his decision was overturned on appeal, he was anticipating or perhaps hoping that the Court of Appeal, in light of the findings that he had made, might then determine the remaining matters. Now, I acknowledge that there is some force to the point, that it is perhaps unusual and in a sense perhaps undesirable for the Court of Appeal to make what are in effect first instance determinations. But nonetheless, it does strike me that on a proper analysis of this judgment and the pleadings, the Court of Appeal is in a position to do so in my client's favour. So if I just take my lords and my lady through the three aspects of this. The first is no breach of duty. In my learned friend's skeleton, there are three ways in which it's suggested that on appeal, Mr. Conway acted in breach of duty. The first way, and this is paragraph 88 of the skeleton, Court Bundle 43.3, is that there was a duty to avoid conflicts of interests. Now, one needs to look quite carefully at how that was pleaded at trial. So can I ask you please to turn up the core bundle at page 192. And we can pick up partway through the particulars of claim. And paragraph 33, which contains what are said to be the allegations of breach. And yesterday, as my learned friend helpfully explained how this pleading worked, I think he said, and this is transcript from yesterday on page 83, that paragraph 33.1 essentially contains some pleadings of fact. And then it was paragraph 33.2 on the next page, which sets out why Mr. Conway's conduct is supposedly wrongful. And I think the central paragraph is 33.2.1, where it is said both the lease and underlease preferred the interests of Lodgeshine, and the failure to take action preferred the interests of Galliard Hotels. And then, somewhat inconsistently with that last bit, the next sentence begins, further, Mr. Conway so acted, whilst hopelessly conflicted, and in each case preferred his own interests. Now, it's very, very difficult, in my submission, to discern from that paragraph what the actual breach of the no duty, the no conflict duty is said to involve. There is no, or at any rate, no clear allegation of a positive breach of duty. And I would respectfully endorse what my Lord Justice Newey said yesterday, that the no conflict rule doesn't involve a positive duty of that kind. It entails simply not being placed in a position where you have a conflict. So that's the allegation of breach. In terms of restorative,
I mean, that may not be the only allegation of breach in there.
That may not be, but I'm concerned particularly with what is said to be the breach of the no conflict rule, which is the first of the three breaches mentioned at paragraph 88 of the skeleton.
Does one have to read? I mean, we don't want to get into interpretation, but does that have to be read together with 33.1? Because it says further.
Well, I think so. I'm not trying to. I don't wish to take a sort of pernickety pleading point. Obviously, the two paragraphs are to be read together, and indeed they are sub-paragraphs of the same paragraph, if that makes sense. But as my learned friend explained yesterday, 33.2 contains, as I think he put it, details of why Mr. Conway's conduct is wrongful. So that's really where one needs to focus. And then following on from that, in paragraph 34, this is where one sees a claim for an account. But importantly, the claim is that Mr. Conway is liable to account to the claimant on the footing of willful default. Now, nothing much was said about, in fact, nothing was said about that yesterday at all. Initially, my learned friend in his oral submissions disclaimed any suggestion that there was an claim for an account of profits. That's page 81 of the transcript. But insofar as this claim for an account is said to be a claim for an account of profits. It's not, because when you are said to be liable to account on the footing of willful default, that simply means that the trustee has conducted himself with a lack of ordinary prudence or due diligence. And when you account on that basis, what the trustee has to account for is not only what he's received, but also what, but for his lack of due diligence, he might have received. Effectively, the trustee is charged with negligence. And so that's really unrelated to the breach of the no conflict duty. It seems to be a kind of fault-based claim for an account. And then, aside from that, it's not obviously clear that there is really any kind of case on causation pleaded that arises out of the breach of the no conflict rule. It doesn't say, well, had he acted in this way, then this is what would have happened, and the consequences would have been X, Y, and Z. So I'd suggest that on the pleading, it's simply not open for South Bank to seek recovery for breach of the no conflict rule. But in any event, I'll just make a couple of other short observations. Even insofar as there was a breach of the no conflict rule, it could only possibly bite in respect of the underlease, because as regards the lease, Mr. Conway owes no duties, as a director at least, to South Bank. He only owes duties to South Bank as his director of that company. So the breach of the no conflict rule could only possibly be engaged as regards the grant of the underlease, it seems to me.
Why is that so? I mean, he had potentially decisions to make as a director of South Bank, conceivably as to whether to put a notice on the register or whether to apply for injunctive relief or in some other way to prevent the lease being granted. And in that context, he clearly had a conflict, didn't he?
Well, I mean, I suppose theoretically, and I say theoretically because none of that is pleaded. Conceptually, I can see, I suppose, that you could plead a case along the lines that at date X, in advance of the lease or the underlease being granted, Mr. Conway was advised that the way you protect the interest under the freehold sale contract is by registering a notice against the charges register of the title. But Mr. Conway decided he didn't want to do that because he wanted to grant the lease instead. I can see how that would be a breach of his duties to South Bank, even though, as it were, it sort of, in a broader sense, engages questions to do with the lease. But as I said, none of that is really pleaded. The only thing that's pleaded in 33.2 is, I said it's very difficult to say what is pleaded, but it just simply refers to the lease and the underlease.
It specifically says, doesn't it also, both the lease and the underlease prefer the interests of Lodgeshine and the failure to take action against Galliard Hotels. So perhaps that fits in with a sitting on of hands in relation to what one might have done as a director of South Bank.
I think the failure to take action point is to do with a later period in time when the transfer came to be executed, where I think the complaint is that at the point when the transfer came to be executed, what South Bank didn't do was take steps to procure, I think, in very broad terms, the surrender of the lease or something like that.
Okay.
That's how I understood the point was developed at trial anyway. So that's what I would say about the breach of the no conflict rule. The other point I'd say, just before I move on, is that in a sense it's quite difficult to see how there was a conflict of interest, or if there was one, why it wasn't waived. Because what you have at the time when the lease and the underlease are granted is effectively some group companies all under the same ownership, entering into transactions for the benefit of the group. And what's more, all parties to the transaction were fully appraised of the advice given by Mr. Phillips, explaining what they were doing and essentially giving it an approval from a legal perspective. And in those circumstances, it's quite hard to see how either there was a conflict, or, as I said, if there was one, why it wasn't waived by all the participants to it. The second ground of complaint, this is paragraph 90 of my learned friend's skeleton, is to do with the breach of the prohibition on self. I'm not sure if that point's really being pursued, because yesterday my learned friend said, it's page 87 of the transcript, that it doesn't really matter. But in any event, the judge held in his judgment, and I don't think I need to take your lordships to it and my lady to it, it's paragraphs 440, 441 and 457, that the prohibition on self-dealing wasn't pleaded, and there's been no appeal against that aspect of his determination. Thirdly, we get on to breach of the duty to act in good faith, which is paragraph 93 of the skeleton. And yesterday my learned friend submitted that the test of good faith is only subjective if the defendant director has considered the separate interests of the particular company in question. Now, assuming that is the case, that is what the judge found in this particular instance. So could I take you please to the core bundle, page 95. Paragraph 175. There is a paragraph that sets out certain factual conclusions as to Mr. Conway's knowledge of or belief in the existence of a conflict. And in that context, one can see, amongst other things, going to this next page in Roman 5, where it's apparent that Mr. Conway had given some thought to the position of South Bank. He didn't think that the transaction would be of disbenefit to South Bank.
By reference to his starting point.
Yes.
And his starting point was obviously adverse to South Bank, because he understood that South Bank had a contractual right to the land and he was doing something to do down South Bank.
Yes, but I'm not sure that matters. The nub of my learned friend's point yesterday is this question of breach of duty of good faith may well import a subjective element. So as a matter of fact, subjectively, did this director act in good faith? And on the facts of the judge, that is the case. Mr. Conway did act in good faith because he acted honestly, and the judge found at various points he acted reasonably in the transactions.
So I suppose there are two things. One is, if he didn't think separately about the interests of South Bank, then Charterbridge comes into play. But before you get to Charterbridge, you say, did he think separately about the interests of South Bank? And he did not think that this was in the interests of South Bank. Even so far as he thought about the interests of South Bank, he thought it was contrary to the interests of South Bank. Must have done, because he realised that this involved a breach of South Bank's contractual rights.
Well, I'm not sure he realised that.
Well, I thought the judge found that he did realise that.
No, I think on the contrary, my lord. If one goes back to the findings, and in particular, paragraph 170. In fact, 169 and 170. At 169, it's the point I took you to at the beginning of today, Mr. Conway genuinely and reasonably formed the view that Mr. Phillips had advised that the scheme was an appropriate way to prevent a mistaken transfer of the annex, which would not involve Galliard Hotels in a breach of trust or breach of contract.
Well, going back to 164, the judge accepts that Mr. Conway didn't know about the contract specifically, but he was aware in general terms that there was a contract that would otherwise operate to transfer the whole title. So forget whether he knows there's a breach of contract. He knows that there is a contract under which South Bank is going to get the whole title, and he is deliberately doing something to stop it getting the title. And insofar as he was thinking about South Bank's interests, I can't see how you can construe that as acting in South Bank's interests.
Well, I'm not sure I would say. I mean, again, maybe I may be agreeing with my lord. I don't think I would suggest that that would be in South Bank's interests. But the question the point I'm getting at is a slightly different one, which is in order to ascertain whether there has been a breach of the duty to act in the best interest of the company, you first have to work out, well, what test do you apply? What my learned friend relies upon are some authorities that tend to show that if you haven't given any separate thought to the particular company, you apply a purely objective test. But if you have given some thought to the company, you apply a subjective test. And so, as I said, I think it seems to follow. The first thing you need to ask yourself is, well, did Mr. Conway give some separate thought to the company, to South Bank? If that's right, then you know which test to apply. And so my submissions at this stage are directed at identifying the correct test. And in light of the findings at 175, I would respectfully suggest that Mr. Conway did give separate thought to South Bank. Now, it may well be, and again, the judge made no findings about this, it may well be that the view he came to was wrong, and he ought to have appreciated better, or whatever else it might be. But what you don't have in the judgment is any finding that, as regards South Bank, Mr. Conway acted subjectively in bad faith. On the contrary, all of the findings on the part of the judge that I took my lords and my lady to this morning are to the effect that Mr. Conway acted only honestly and reasonably, and what's more, on the basis of independent, well-qualified legal advice.
Is this duty actually the duty to promote the success of the company?
Well,
is that because that's the statutory duty, isn't it?
Yes, I mean, it's slightly complicated by the fact that in 2008, I'm not sure whether all of the Companies Act duties have been brought into force. But for what it's worth, if one looks back at the pleaded duties at page 192 of the callback,
There's 30.2 Act in good faith to promote the success of the
I
company.
think that's the relevant duty that's pleaded.
Mm-hmm.
Okay. If that is the right formulation, how could Mr. Conway have thought it was in the interests of the company to do this, given the judge's finding at 164? You say there isn't a finding that he was dishonest, which is true. But how could he actually have thought it was in the interests of the company to do it, rather than not being dishonest in doing it?
Well, respectfully, my lord, that's the wrong question. The question is whether, looking at the pleaded duty, Mr. Conway failed to act, quote unquote, in good faith to promote the success of the company. He may well have failed to promote the success of the company because
he's got to believe, sorry to cut across you, but the test is he's got to believe that what he's doing is in the interests of the company.
But that only
And he's got to believe in good faith that what he's doing is in the interests of the company.
Yes, in good faith, which I think imports the question of whether or not what he did was in good faith.
But he's still got to believe it's in the interests of the company.
Yeah. Well, I suspect that, yes, I think that must follow. Yes, I would accept that.
So, is there a finding here that what he did was something he believed was actually in the interests of the company?
I don't think I can point to any finding that goes that far, no. I think the closest I can get to is paragraph 175. And in particular, Roman 5.
That seems to be a finding that there was no disbenefit.
Yeah, well, yes. So it wasn't a positive benefit, but certainly no disbenefit by his perception that Mr. Evisha's suggestions to increase confidence in facilities would increase South Bank's revenue.
I also don't really understand that. That's saying there's no disbenefit if one assumes to start with that one has no interest in the annex. So I'm confused by that.
Well, I think the way the judge looked at this, and one has to go back to his findings as to the events in 2005, is that this was part of, if you like, a continuum. That in 2005 there was this discussion with Mr. Evisha, which led to a significant expansion to the common facilities at the hotel at no doubt significant cost to Galliard. And as part and parcel of that, it gets the annex. And effectively, what one discerns from the memo, although this is not how the judge decided or stated it, but Mr. Conway in 2008 says, well, this is what basically should have happened. Is it now too late? That's sort of how he viewed it. So in a sense, I think what the judge is saying is that from Mr. Conway's perspective, South Bank was getting the upside from all of the increased and better facilities, and as a consequence should have to bear the burden of paying for the annex, which would otherwise have, according to Mr. Conway's generalised understanding, have remained with Galliard. That's how I understand paragraph 175 sub 5 at least.
Thank you.
But I mean, even if I'm wrong about that, and one has to apply a purely objective test, what you would need to, I think, plead and prove is that an intelligent and honest man in the position of Mr. Conway, as director of South Bank, could not, in the circumstances, reasonably have believed that the grant of the lease and the underlease were for the benefit of that company. And that again is just simply not something that was ever pleaded or canvassed at trial. So can I move on then as quickly as I can to the next aspect, which is the duomatic point. My learned friend in his skeleton queried whether I can even pursue this point in light of the observations of the judge at, I think, 176 and 177 of the judgment, which cross refers to the direction the judge gave in paragraph 23. The difficulty I think everyone faced in all closings, we had a day each to deal with a tremendous amount. We just simply didn't have time to go through everything we wanted to. And that's why, for what it's worth, the judge is quite right. I didn't make oral submissions on the duomatic point, but it was there in our written closings, and it was certainly not something conceded. And in fairness to my learned friend, I don't think he pressed the point extensively yesterday. But assuming it's open for me to take the point in this court, the question then is whether duomatic applies on the facts found, or the inferences to be drawn from the facts by the judge. Now, in this context, I think there are two important preliminary points to get out of the way. The first is that South Bank does not contend that the grant of the lease or the underlease were in any sense ultra vires and not capable of ratification. And the second point is that South Bank cannot, in light of the judgment, suggest that the grant of either instrument involved bad faith or dishonesty. And the reason those 2 points are important is because then, in principle, the duomatic principle could save the transactions. So the point then taken against me on appeal is that there was no evidence of ratification. As my learned friend put it yesterday, there can't be an intention to ratify where the shareholders haven't even considered the matter in question. In my submission, the most useful authority here is the Saiban or Chaiban case at tab 47. Which is, I think, in volume 4. This is a decision of the Privy Council, so not obviously technically binding on my lords and my lady, but no doubt of some persuasive force, if nothing else. And it's important to look at the facts of this case quite carefully. Because on the facts, the geomatic principle is applied, notwithstanding that the shareholder didn't even know about the transaction in question. So what one has here, one picks up at page 1357, is a dispute involving a company called Spectacular, as you see in paragraph 1. And the company, Spectacular, brought a claim against 2 other companies, one called Sitco BVI, and the other called Tortola Corporation Limited, who are respectively agents and directors of the company. And the complaint, and you see that from paragraph 2, is that Spectacular, the companies issued on the 15th of August 2001, on behalf of Spectacular, power of attorney, described in the judgment as the 5th POA, under which someone called Mr. Delolo was authorised to sell certain parcels of land. You can see by letter B on page 1358 that someone called Mr. Byington was the ultimate beneficial owner of the company, Spectacular. And after that, you see that Mr. Delolo used the 5th POA in order to conclude a contract for the sale of land. Now, just picking up the facts in a bit more detail, turning to page 1360, you can see in paragraph 10 that Mr. Byington is a Brazilian businessman. And in paragraph 11, he persuaded a friend of his called Mr. Costa to acquire 2 BVI companies in order to orchestrate a scheme by which the share capital in another company, GEL, would be sold to Mr. Costa through those intermediaries in order effectively to take money out of the reach of Mr. Byington's creditors. And that then led to a fairly convoluted set of arrangements, resulting in paragraph 12, Spectacular acquiring these properties, which were subsequently sold. If one goes to paragraph 15, you can see that between certain dates in 98 and 99, Spectacular issued 3 POAs to Mr. Delolo. And Mr. Costa, who was the associate of Mr. Byington, communicated the instructions to issue these POAs directly to the Sitco BVI or to a different company, Sitco NY, after which they were passed on to Sitco BVI. Each time the instructions were followed without question, and Mr. Byington gave his approval, this is, I think, the most important bit, for all the corporate acts carried out in Spectacular's behalf from its acquisition up to and including the issue of the last of these POAs in September 99. As Bannister J noted, there was no document at trial to suggest that Mr Byington had told any of the professionals with whom Mr Costa dealt on his behalf they could rely on his instructions, nor was any evidence that any of them had ever asked Mr Byington for confirmation of those instructions. And then paragraph 17. There you see description of events leading to the issue of the 5th POA, and then the sale of the property under paragraph 18. Now, there is then some treatment of the duomatic principle in paragraph 31, page 1365. And I don't think I need to take my lords and my lady through the summary of the legal principles. It's probably sufficient for my purposes. I take you to 1367, paragraph 37. Where it is said, applying the duomatic principle to our case, Spectacular would have been bound had the sole shareholder, Mr Byington, consented to Mr Costa's having authority to give instructions. That informal giving of consent by Mr Byington explains how Mr Costa had actual authority to give instructions to the EDI companies in relation to the first 4 POAs. In respect to the 5th POA, Mr Byington clearly did not consent. The question therefore becomes whether one can apply the duomatic principle of informal unanimous shareholder consent to ostensible authority. And he goes on to say here, Mr Byington's informal consent to the representation by conduct that Mr Costa had authority to instruct TCCL in relation to the 5th POA binds Spectacular. And at 40 onwards, Lord Burrows didn't think there was any particular reason why duomatic couldn't apply in this context. And then we see at paragraph 42, the relevant bit. In the present case, it might be suggested that the single shareholder, Mr Byington, was not aware of and therefore could not have consented to Mr Costa's giving instructions for the 5th POA. However, Mr Byington had set up a mode of operation which particularly BVI and TCCL reasonably relied. The very concept of ostensible authority means that Mr Byington should not be allowed to deny that he consented to the giving of authority to Mr Costa. So this is a situation where, in fact, the shareholder, so far from having an intention to ratify the alleged breach, didn't even know about it at the time.
That was on the very particular and unusual facts of that case.
Entirely accept that, my lord.
And the principle seems to be the one that's set out in paragraph 41, where the words of Mr Justice Newberg go. The requirement can be avoided if all the members of the group being aware of the relevant facts give their approval. And then this decision we're looking at now is a rather unusual case where it was found that that wasn't needed because of the way that the
Everything had been set
up.
up. Yeah, and it's exactly the same in our case, in my submission. There's no difference, because if one looks at the evidence that the judge quotes at paragraph 176 of the judgment, core bundle 96, in effect, the other directors of the shareholder essentially derogated strategic decision-making for Galliard's business, as it's put in there, to Mr Conway. So a bit like how Mr Byington sets up a mode of operation where Mr Costa is effectively allowed to give instructions on his behalf. It's the same mode of operation vis-a-vis the parent or the of SBHMC. Well, that's I think what I want to say on Duomatic. I'm going to have to move on, I'm afraid, to the question of relief.
Yeah.
Unless my Lord Justice Miles has anything.
Well, sorry, I know that I don't want to cause you to jump around, but I just would be interested in your submission on a different point,
Of course.
which was the earlier point about control in relation to Lodgeshine.
Yes.
Can I just go back to this paragraph
Yes, of course.
that you just took us to?
Of course.
Because what your client said was that in reality I was, in the sense that I controlled the board of homes. So he's saying he was the controller of, I think he's saying, is he, that he was the controller of Galliard Homes.
I think he's saying he was the controller of the board of Galliard Homes. Yes.
But Galliard Homes was then the 100% shareholder of Lodgeshine.
Yes, that's correct.
Sorry to take you out of your course.
Moving on then, if I may, to the question of relief. So this is section 1157 territory, and I don't think I need to take you back to the statutory provision. Can I take you to the pleading, see how this was put at trial? We go to core bundle page 270. And paragraph 60 of the counterclaim pleads that Mr. Conway ought fairly to be excused under section 1157. Jumping to page 315, we see the beginning of the defence to counterclaim. And then the relevant response is at 317. Paragraph 41. So it denies paragraph 60 and repeats paras 23, 26 to 8, and there looks to be a broken reference, so I don't know what that is, are repeated. And it's denied that the conduct of Mr. Conway was honest and reasonable. So if one cross-refers back up at least to 23 and then 26 to 28. 23 is to be found at page 307, I think. And that pleads Mr. Conway's knowledge, I think, of certain facts and matters. Then turning to 26 at the bottom of page 308. There's reference in paragraph 26 to C1 capital, that is. And then 27 and 28 are largely to do with insurance, which was an issue that ended up being dropped in advance of trial. So when one goes back then to paragraph 41 at 317, having unpacked paragraph 41.1, it cross-refers essentially to matters which go to Mr. Conway's state of mind. And then 41.2 is Mr. Conway's experience as a property developer. And then 41.3 is about losses which have been suffered by South Bank. which have been caused by the actions of Mr. Conway. So what the pleading doesn't rely upon is the fact, if it is a fact, that relief should be refused because Mr. Conway has come off with something that he ought not to have received. Now, on the evidence, the court found that Mr. Conway did act honestly and reasonably in connection with the grant of the lease and the underlease. And there's no appeal against any of those findings. Although yesterday my learned friend suggested orally that actually this court can conclude that Mr. Conway acted unreasonably, but in my respectful submission, that's simply not open for this court to do. So, if you like, the threshold conditions for the application of Section 1157 are engaged. So we have findings that Mr. Conway acted honestly and reasonably. The only question then is whether, for the pleaded reasons in paragraph 41.
Sorry, can you just remind us where the judge held that it was reasonable?
Yes, of course. So there are quite a few findings to that effect, but so why don't I pick up at page 93 of the bundle? At paragraph 167, it was reasonable in 2008 for Mr. Conway to believe that there had been a mistake. Paragraph 169, Mr. Conway acted both genuinely and reasonably formed the view. And another example, paragraph 175, sub-Roman 4, it was reasonable for Mr. Conway to approach matters as set out in paragraph 175.3. There may be some other instances in the judgment, but certainly what one takes from that is that the judge concluded that Mr. Conway behaved reasonably because he was reasonable in the approach he took. In a sense, that's unsurprising because, of course, he only acted on the basis of legal advice that he had received. So it'd be a bit difficult for someone to say he acted unreasonably in those circumstances. And so what you then have is a situation where, assuming that there has been some breach of duty, which of course no one has determined, it was a breach of duty that's happened now 17 years ago, in respect of which Mr. Conway acted honestly and reasonably, and as I said, on the basis of legal advice, and a bit difficult to see why he ought not to be fairly excused.
Well, of course, you say 17 years ago, this would be an ongoing effect for the next 980 years. I'm sorry, my lord, I'm not sure that's right though, because that of course relates to the grant of the lease. We're here concerned with Mr. Conway's breach of duties as director of South Bank. And I appreciate that we get back into the debate. We do, but I mean, the fact is that on this thesis, Mr. Conway is benefiting from the right to receive rent of 170,000 a year, index linked, for another 980 years, isn't he?
No, that's respectfully, that's not right. The right to receive rent arises under the underlease, the term of which, as it happens, has expired. So, subject to, and we'll see how this plays out in ground 3. What South Bank can get is obviously a renewal under the 54 Act.
But he has the benefit, putting it another way, he has the benefit of, or rather Lodgeshine has the benefit of owning this property.
Well, that as a matter of fact, that is of course
900 odd years.
Yes, as a matter of fact, that is of course correct. But that is again, subject to the debate I had with my Lord Justice Newey, that is unrelated to the breaches in respect of which he is seeking relief from liability under section 1157.
Well, I think this is all on the hypothesis. This argument arises on the hypothesis that there is a relevant breach.
Yes.
With him as a director of South Bank. So you've got to assume that against you. I quite understand your arguments on that point.
Well, but that still begs the question, what's the nature of the relevant breach? Because if the relevant breach is, as I would suggest it has to be for these purposes, unrelated to the grant of the lease, then he's not coming off with any property in respect of that breach. He might, Galliard Hotels or Lodgeshine might be coming off with, well, Lodgeshine might be coming off with some property, arguably by reason of a breach of the trust obligations imposed on Galliard Hotels, but that's something completely different. So, my Lord, I think I'm going to move on because it's now 3:10 and I've got to deal very quickly, I'm afraid, with the remaining validity grounds. I'm sorry I've gone on longer than
Nope.
I apologise. So before I make submissions on the validity issues, it is actually worth for a moment reflecting on how they might play out if South Bank's arguments are accepted. And the reason I say that is because South Bank's arguments present it with something of a problem. The validity grounds take as their start point the deeming provision in the Companies Act, which we can go back and have a look at. It's in Authorities tab 6, page 43. And the relevant provision is sub 5, at the bottom of the page, which begins in favour of the purchaser of documents deemed to have been duly executed if it purports to be signed. And then there's a definition of purchaser on the next page. I think, or at least as I understand it, South Bank accepts that as regards the lease, Lodgeshine is the purchaser, is the lessee. And that means that Lodgeshine can rely upon the deeming provision to validate the document. And that means that subject to South Bank's ground 4, the lease is a valid lease and will stand. And I think my learned friend accepted that point yesterday, page 109 of the transcript.
That's subject to it being a purchaser, though, isn't it?
Well, subject to being a purchaser for in good faith.
Within the definition of the section.
Yes, and so if one looks at that definition, my lord, at page 44, so the top, you can see a purchaser includes a lessee, and so as regards the lease, the purchaser, the lessee, is Lodgeshine.
So, as you say, it's ground 4, which is good faith.
Exactly. So, subject to ground 4, arguments on good faith, the lease stands. Now, as regards the underlease, of course, South Bank was also the purchaser because it's also the lessee. And what South Bank says is it doesn't want to rely upon that deeming provision. I say it can't do that, but anyway, let's assume that that's right. It means then that the underlease was not validly executed as a deed. And the consequence of that, in this extra blue bundle, you can see from the Law of Property Act, section 52, and section 52(1) states that all conveyances of land are void for the purposes of conveying or creating a legal estate unless made by deed. So that would be the consequence if they get out of section 44. But then South Bank goes further and says not only is the lease void for creating a legal estate, but also it's not an equitable lease either, because it's not or can't properly be the subject of a claim for a specific performance. But even then, again, assuming that's right, the lease is still a contract between two parties, and in these proceedings, South Bank has never sought, I don't think, or he doesn't now seek to rescind that contract. So it is still an effective contract, albeit not one that's made by deed, and it's not one apt to create an estate in land. And that then causes South Bank some real problems because, as I indicated, but actually haven't even looked at the underlease yet. If we go to the supplementary bundle, and goes to find page 59, one will find the underlease, and then you see the definition of term on page 63, 15 years from the date thereof, so 16th of June 2008. So the contractual term expired in 2023.
Sorry, that was page.
Page 63, clause 1.25 is the definition of term, and then you have the grant or the demise in clause 3 at page 64. What the consequence then is, if South Bank, if the lease is void at law and in equity, South Bank then loses its rights of renewal under the 54 Act because it doesn't have a tenancy. So it's difficult really to understand why South Bank wants to run these validity arguments, which seem contrary to its commercial interests, indeed very seriously contrary to its commercial interests. But nonetheless, that is the point that South Bank wishes to advance, and so therefore it's the point I need to meet. So I'll deal first then with South Bank's ground 3, which is the deeming provision. I've taken a preliminary point that it's not open for South Bank to raise this argument since it was effectively abandoned at trial, and I've referenced paragraph 430 of the judgment. I don't think I need to take you further to that. If I'm wrong about that, one has to look at the provision itself. So if we could go back to that, please. Again, it's tab 6, page 43. You can see that in favour of a purchaser, a document is deemed to have been duly executed by a company if it purports to be signed in accordance with subsection 2. So it's fairly clear in its wording, I would suggest, that where a document purports to be signed in a particular way in favour of a purchaser, it is deemed to have been duly executed. And my essential submission is that once that deeming provision takes effect, it takes effect for all time and for all purposes. What you can't do is sort of deem in and deem out at your election. In terms of the approach to deeming provisions, we've referenced a case called Marshall.
There isn't an allegation of waiver here, is there? The point you just made, you've got your option and you can't go in and out of it. But there isn't a case, a sort of Payman and Lanjani type argument of election.
No, because there isn't, because I think that's more a point that South Bank seeks to argue in its skeleton argument. It seems to suggest that Section 44(5) allows you to elect in a sense, which and they have referred in their skeleton argument, if I'm not mistaken, to a provision from Boasters on Apes. I think it's, if I have that correct.
Sorry, I don't wish to take you out of the course, but it's just to confirm, there isn't. You haven't raised an argument of a waiver of the right. Your point is just once and for all, if the circumstances are met, then it's deemed without the purchaser actually doing anything.
Yes, I'm not. We haven't run a waiver argument because I don't think it's even apt. I say obviously with defendants to talk about this being a right. It's just simply the operation of a statutory provision,
So can I be clear? The underlease is executed on whatever date in 2008. There and then, it is deemed to have been duly executed and forever.
In favour of the purchaser.
Well, just in favour of the purchaser. Let's leave those words out of it for a moment. Do you say that as soon as it was executed, it was deemed to have been validly executed forever?
Yes, absolutely.
And do you also say that because of that deeming, it wasn't merely open to South Bank to say that, but Lodgeshine could say it as well from day one?
No, I think. I think one has to give obviously some content to the words "in favour of a purchaser." So I think you have to. Those words are there for a reason.
So at what point did Lodgeshine become entitled to rely on this?
Well, I'm not sure, with respect, that's even necessarily the right question about reliance. It's just simply that, as I said, one has to ask, well, how does the statute operate? There is a deeming provision in this statute that operates in a particular way at a particular time. And so when one looks at this, in favour of a purchaser, a document is deemed to have been duly executed. And in a sense, it means then the purchaser is fixed with that. The purchaser is, contrary to reality, the purchaser is taken to have, as it were, entered into a contract that complies with all of the statutory formalities.
So hang on, the seller can disclaim the contract, can he? On the basis that there isn't a provision dealing with his position. He can say, no, it wasn't validly executed. But the purchaser can't.
No, I don't think that's how the provision was designed to work. I mean, if one thinks about what the purpose of this provision is, I think that we talked a bit about purpose in the context of Section 21. The purpose is obviously to safeguard purchasers so as to allow them to rely upon the apparent validity of company documents and to ensure certainty and reliability in dealings with companies. That seems
the way
to be...
you were putting it, Mr. Thompson, was the other way up. It wasn't, as you were describing it, a provision which is to assist, if you like, or save the purchaser from having the trouble of actually having to show at some future date that there were two authorised signatories and they were authorised, for example. Yeah. Because it's perhaps out of his control to know whether they were authorised or they weren't. The way I understood what you were saying was the opposite. It was in effect to lock the purchaser in because they couldn't get out of the effect of 44.5.
Well, that is the effect, and there's nothing untoward about that. That the point of Section 44.5 is to uphold commercial transactions and not allow parties to get out of them for technical reasons. That it promotes.
But then what's the in favour of? I mean, it doesn't need to say in favour of a purchaser at all on that basis, does it? It can just say a document is deemed to satisfy little two, because we say it does.
Well, it may be that the answer is because, first of all, as your ladyship has indicated, a purchaser won't know, or at least not at any rate won't necessarily know, the constitutional workings of the company with which it is dealing, or whether the company is a victim of a fraud or whatever. And so you can't, or at least in order to avoid this provision becoming a vehicle of fraud, you wouldn't expect it to say in favour of a vendor or whatever the opposite of a purchaser is, because otherwise then let's suppose an agreement was entered into by a director defrauding a company, the company couldn't then, as it were, sue the director for breach of whatever his duties are, or do whatever the company wants to do. So that's, I think, is why you have those introductory words in favour of a purchaser. But nonetheless, the purpose of this is, in my submission at least, is still to uphold transactions. That's why it's there. It's to promote certainty in dealings. And one can test it this way. If this provision was to allow a purchaser simply to elect at any time whether or not to take advantage of the document, I mean, it would give rise to tremendous uncertainty, because you could have a situation where the purchaser decides to rely upon the deeming provision for X number of months, and then a new management comes in, as in fact happened here, and thinks better of the transaction. If Section 44(5) worked in that way, it would become sort of practically impossible to manage certainty of dealings between corporate entities.
Can I just go back to the point I was half raising a moment ago? So suppose that there is a sale by an individual to a company, and suppose that the company doesn't then execute the document properly. What would be the vendor's position?
So an individual sells something to a company,
And the company hasn't executed it properly.
well, in that situation, the deeming provision in Section 44(5) is simply not engaged.
So the vendor can say, no, this isn't valid. And the vendor can interfere with the upholding of commercial transactions and get out of it.
Well, in theory, I mean, subject to whatever any other defences or anything that might be run. But
Right.
yes, as a matter of theory, yes, I accept that.
So why isn't this reciprocal? Why does it only operate in favour of purchasers?
Well, I'm not sure, respectfully, that there's a meaningful difference in this sense, because once it operates in favour of a purchaser, then that is the document. It has to be upheld in favour of the purchaser. So to take our example, under Section 44(2), the document has to be signed in a particular way. It wasn't, but I don't think there's any dispute that it was purported to be signed in that particular way. And therefore, in favour of South Bank, I would suggest for all purposes, it has to be deemed to be properly executed, which means that South Bank has to be taken to have taken a valid grant of the underlease. I don't see how South Bank can effectively disclaim the effect, what I would call the automatic effect of Section 44(5), simply because it doesn't like the transaction, which is what South Bank was trying to do in this particular case. It operates. You just simply have to ask yourself the basic question: how does the provision operate? And
is it there for the protection of a purchaser?
Yes.
Then a purchaser says, I don't want that protection.
Well, that raises the question, which I think is buried within South Bank's submissions, that this effectively allows you to elect whether or not to rely upon the deeming provision, which I venture to say is a question of statutory construction. And in my submission, it's important to look at the word "is" in the first line of Section 44(5). It doesn't say in favour of the purchaser a document may, at the purchaser's election, be deemed.
What significance, on your case, do the words "in favour of a purchaser" have?
Well, it means that when the underlease was executed, not in compliance with the requirements, in favour of South Bank at the point in time when it was executed, it was deemed to have been duly executed, and therefore it is taken to be a legal lease.
So Lodgeshine can rely on the deeming in favour of the purchaser.
Well, I mean, yeah, yes, in the sense that in the context of this dispute, Lodgeshine was relying upon the effect of the deeming provision. Which I suppose still begs the question, what is the effect of the deeming provision? And because ultimately what South Bank's arguments entail is that South Bank was allowed to rely upon the deeming provision when the underlease was granted, because it proceeded to register the underlease at the land registry. But then fast forward some 16 odd years in the Chancery Division, South Bank turns around and says, actually, no, the document is not deemed to have been duly executed. That's essentially what South Bank's submission boils down to. And in my, I would respectfully suggest that's simply not how Section 44(5) works, or it's intended to work. My lords, I do apologise. I'm going to have to move
Yes,
on.
no, quite.
I've got to finish really in 30 minutes to allow my learned Julia to have a fair
Yes.
go. Can I move on then to the question of good faith in Section 44(5)? So this is South Bank's ground 4, and there are essentially two issues which arise under this ground. The first is a point of statutory construction, i.e. what is meant by good faith for the purposes of Section 44(5) of the statute. And yesterday my learned friend submitted that whatever else the concept entails, what this provision is not there to do is to protect someone who, in his words, knows of the very fact which renders the execution of documents invalid, and indeed knows that they've not been executed in the manner described in Section 44. And in my submission, that's not how Section 44 operates at all. If one goes to the Lovett case, which is in tab 31, is volume 2. That was a case that actually has some similarities to the present. It essentially concerned the question whether or not a signature on a debenture was forged. That was the essential issue. And if one goes to page 652, paragraph 51. Paragraph 51 says, this is one of the most unusual features of this case. The evidence showed clearly that Mr. Jewson had in the past been in the habit of himself signing Mr. Carter's purported signature on bank documents. So it's a bit like Miss Akers and Mr. Conway. And paragraph 55, my view, having regard to the evidence, is that in reality Mr. Carter did not mind and was perfectly prepared to accept that Mr. Jewson could sign documents in the name of Mr. Carter, provided that Mr. Carter knew in general terms of the underlying transaction. So again, similar kind of setup to what we have in this case. If we go then to page 658, at para 79, the judge concluded that the bank under the debenture was a purchaser, and that the word purports in section 44(5) is a wide word which operates to refer to the impression a document conveys. And then jumping to paragraph 96. See the reasons the judge sets out in that paragraph, and I won't read through it all now. The judge concludes that section 44.5 operated in favour of the bank, notwithstanding that Mr. Carter knew that Mr. Jewson signed his signature as him.
But maybe I'm misunderstanding the facts. The bank is the purchaser,
Correct.
and this isn't a signature by the bank.
No, it's not. But I suppose what's important in this case, I think, is that the section 44.5 operated even though the sole signatory, so or the person who intended to sign, Mr. Carter, knew of the relevant defect in the signature on the debenture.
But that doesn't tell you, does it, anything about the meaning of good faith? If good faith is dealing with the position of the purchaser, and the bank was the purchaser and didn't know about the problem.
No, and I'm just going to come on to good faith in a minute, but I think the reason why that's instructive is because actually the meaning of good faith in the context of section 44.5 isn't quite limited in the way that my learned friend would suggest. That we have, I think my Lord Justice Newey's invitation yesterday, spent a little bit of time trying to find some authorities under section 74.
Any success?
Well, we have found one case, again in the blue little additional bundle, which is a case called Smith and Morrison, which is not actually decided under section 74. It concerns a different statutory provision. But nonetheless, there is some instructive remarks of, I think it was Lord Denning. I'll get my own copy. Yes, it's at page 670 of the report. Where Mr. Justice Plowman, between letters A and B, turns to the question of good faith. And then towards the bottom of that page, he cites from the judgment of Lord Denning, Master of the Rolls in Central Estates and Woolgar, where Lord Denning refers to the formulation of good faith in a variety of different statutory contexts. And ultimately, I think where the authority lands up is just a basic question whether or not the purchaser has acted honestly or dishonestly. That's essentially what it comes down to. So that's the first issue, so the question of statutory construction. And then the second issue concerns the question of fact, which is whether Mr. Conway acted in good faith as controlling mind of either Lodgeshine or South Bank. I think it's South Bank in this context. In this context, I think the key points are, first, per the judge's findings, Mr. Conway acted honestly as regards the lease and underlease transactions. And more specifically, the judge found that Mr. Conway wasn't aware of the requirements of section 44. And so, ex hypothesi, he can't be said to have known that he failed to comply with those requirements. So he didn't even have notice of a relevant defect in execution in any event. And the relevant findings, if I could just perhaps give you the paragraph references, are at 391, 396, 419, 421 to 422, 426 and 428. So, my lord, my lady, I'm going to move on then to the respondent's ground 3 brackets 5, which is the estoppel point. Essentially, the question is whether South Bank is entitled to argue that either the lease or the underlease don't take effect in law because of a failure to comply with formalities. So, just a couple of legal propositions to begin with. First, as a general rule, a landlord can't dispute his tenant's title, and a tenant can't dispute his landlord's title. There are some passages from Woodfall that you were taken to yesterday, but also there are some instructive observations in the Southern Pacific case, Authority Bundle tab 38, please. Page 901. Where Lord Collins, just by letter F, cites from a case called Cuthbertson and Irving.
And that was page?
901, my lady.
Thank you, I'm sorry. Yes.
Lord Collins cites from a case called Cuthbertson and Irving. And he says, where a lessor, without any legal estate or title, demises to another, the parties themselves are stopped from disputing the validity of the lease on that ground. In other words, a tenant can't deny his landlord's title, nor can the lessor dispute the validity of the lease. So that's the first proposition. The second proposition is that these estoppels, the mutual estoppels, I might call them, survive on an assignment. And if authority for that was needed, there is a case in the bundle called Taylor and Needham behind tab 8. But I wouldn't have thought that that is controversial, so I won't take you to it now. Now, these propositions that I have adumbrated are well illustrated by the First National Bank case, which is behind tab 26 in volume 2. Can I pick up the facts, please, at page 494? You'll be able to see by letter F that the case concerned a legal charge executed by Mr. Thompson and Mrs. McMahon over a property in Middlesex, and between letters F and G, on the date on which the legal charge was executed, neither Mr. Thompson nor Mrs. McMahon were the registered proprietor or entitled to be registered as proprietors. And essentially, you'll see at the bottom of the page that Mr. Thompson objected to the registration of the charge after he had been registered as the proprietor. And his argument, which is at page 496, just after letter A, is as follows. And this is 1, 2, 3, 4, 5 lines down. On the 10th of July 91, when he executed the charge, Mr. Thompson was not the registered proprietor, not entitled to be registered, no right to the legal title at all. And then the bank argues by letter C, although Mr. Thompson could not create a legal charge, the effect of the legal charge was to create a legal estoppel. And Lord Justice Millett then sets out the legal principles at the bottom of page 496 onwards. And you'll see one of those principles at 497 between letters D and E, where the Chief Justice, Lord Mansfield, said, in the indented quotation at the end, "No man shall be allowed to dispute his own solemn deed." And in terms of the application of those principles, what happened was, page 500 of the Bible, between letters B and C, the legal charge executed by Mr. Thompson contained no recital or other representation of title, but it purported to create a charge by way of legal mortgage. And it said, although such a charge does not create or vest a legal term of years, it confers upon the mortgagee the same protection, etc. And by letter D, Lord Justice Millett said it can only be created by the owner of a legal estate, and in my view it must be regarded as a purported grant of a legal estate. And then after letter D, follows that had the case concerned unregistered land, bank would have acquired a legal mortgage. And then importantly, a next paragraph F, whoever else may challenge the validity or effect of the legal charge, neither Mr. Thompson nor Mrs. McMahon may do so. Even if the legal charge is not registrable in law, they may not object to its registration. So even though the charge was incapable of taking effect in law when it was granted, there was an estoppel by title preventing the chargeors from disputing its validity and objecting to its registration. Now, based upon my propositions as illuminated by that authority, this might be thought to be a plain case where estoppels arise. That's because we have a situation where Galliard Hotels grants a lease to Lodgeshine, Lodgeshine grants a sublease to South Bank. Each party is prevented from disputing the validity of each other's grant. The estoppels are fed when the lease and underlease are registered respectively at HM Land Registry. And then in turn, South Bank acquires by transfer Galliard Hotels' reversionary interest to the lease. And so just like Galliard Hotels, it becomes subject to the same estoppel. So it's a very straightforward analysis. The principal point that my learned friend takes against me is that it's not possible to rely on estoppel, he says, when the very issue is whether the lease had been validly executed at all. But in my respectful submission, that argument is unsustainable in light of the First National Bank, where the mortgagee raised the argument that he had no legal ability to grant the charge when he did. It's in substance the same sort of argument that South Bank is raising in these proceedings.
That was the argument, as I understand it, was that they didn't have title.
In the First National? Yeah.
But there was no suggestion that, for example, their signature wasn't capable of being a signature of those people.
No, but qualitatively, however, it's the same issue. In the First National case, the challenge to the validity of the instrument was because they didn't have title when they granted it. In this case, the challenge to the validity of the instrument is because it wasn't signed in a particular way. in another case in the bundle called Munro, a very early case, there was a challenge to an instrument that wasn't executed in the same kind of way, I think by livery and season. And when the landlord sued for rent, the tenant said, well, it's not a valid grant, but that argument wasn't permitted to be run because of an estoppel. But substantively, even though all the arguments ever so slightly different, articulate slightly different reasons for why the instrument is invalid or void, that doesn't matter, because what does matter is that in each of those cases, the person taking under the instrument can't turn around and say to the grantor, actually, no, this is not a valid instrument. That is contrary to the estoppel.
Does Section 44 do anything?
Well, in my respectful submission, yes, because Section 44 is not just concerned with relations between landlords and tenants, or between mortgagors and mortgagees, or people with title. Section 44(5) is found in the corpus of companies legislation and might govern all sorts of contractual relations.
Well, 44(5) deals with purchases.
Yes.
And where you had a transaction that could be described as one of sale or purchase, even taking the extended meaning in Section 44, you would say, well, there are mutual estoppels and that's that.
Well, I mean, it depends what you're looking to use the estoppel for. I mean, if one goes back to the provision itself, it's probably useful to have it to hand. Section 44(5), as one can see, is simply concerned with the due execution of a document, which is a slightly different question as to whether or not someone has.
I suppose that's what I'm trying to work out. So let's take a case that is within 44(5), subject to good faith, where you have a sale and purchase document, a lease, whatever, that has purportedly been validly executed. Will it always be the case that on your submissions there are mutual estoppels?
Yes, in a let's say, I mean, yes, there would be. I think where that provision, where an estoppel arises, then yes. But as I said, one has to be quite clear about what the estoppel, what the effect of the estoppel is. The effect of the estoppel is to prevent someone from denying the validity of the grant, which is, or at least might be slightly different from the question whether or not a document is deemed to have been duly executed.
But the reason you want to deny due execution would be because you wanted to deny validity of the grant.
Section 44(5), so going back to earlier grounds, is concerned with a situation where there's a deeming in favour of a purchaser. So the mutuality of estoppels point, it's a sort of fits in at a slightly different stage of the analysis, where you're concerned with sort of bilateral dealings between parties, and Section 44(5), in my estimation, may not. It doesn't operate, if I put it that way, at that stage. It just simply allows a purchaser, or in favour of the purchaser, allows it to take advantage of a document that bears all the hallmarks of being signed.
So if you have, well, take a lessee who has discovered that, or maybe always knew that the landlord's execution wasn't valid. Well, if they always knew, Section 44 couldn't work, I think. But would the lessee still have the benefit of an estoppel?
Yes, because I mean, it's one of the fundamental principles of landlord and tenant, that you can't, as a tenant, dispute your landlord's title.
Well, that's not disputing title, that's disputing execution.
Well, if one I suppose begs the question as to how the principle operates. I mean, perhaps if I can take you to the Woodfall extract, tab 56. It's tab 56, page 1673. So turning to page 1674. You can see that the estoppel of the lessor works in this way. A lessor by deed is clearly estopped by the lease from denying he had any estate in land at the time of the lease executed. And a little bit further on down, upon the execution of a lease which operates by estoppel, there is, in contemplation of law, created in the lessor a reversion in fee simple by estoppel, which passes to his assigns. And it goes on to say, a lessor is stopped from contending he had merely an equitable interest when he granted the lease. And a little bit further on, goes up, this is 1, 2, 3, 4, 5, 6 lines up from the bottom. Dealing with estoppel by title, the landlord is estopped from denying he had no title at all. It appears that if he had some title, this kind of estoppel will not apply, and the tenant will acquire a legal estate, one which does not exceed that of the landlord. And then 2 sections on, tenant is stopped from disputing landlord's title. The tenant is stopped from disputing the title of his landlord. Then one goes over page. Thus, a lessee cannot dispute his lessor's title by setting up an adverse title. And likewise, 3 lines down, in an action for rent, the tenant is stopped from saying the lease is not a good one. And that's, then you see the reference to the Munro case in footnote 4. And then towards the bottom of the section, 3 lines up, for as long as the estoppel lasts, it seems that the tenant is stopped from claiming that his landlord has a lesser estate than the freehold, in a rate where the landlord in fact has no title at all. So that seems sort of a clear enough summary of how the estoppels operate. So it just strikes me that they operate in a different way to the deeming provision in section 44.5, which is directed at a slight thing.
There's a requirement. I mean, the starting point for this is as set out in paragraph 401 of the judgment, isn't it? Where there's a requirement that for the lease and the underlease to take effect as conveyances of legal title, they must be made by deed. That's what the Lord Court here says.
Yep.
So there's a requirement that there be a deed. There's then a requirement in the LPMPA about what that means for these kinds of transactions. And one of the requirements is that it's validly executed. And then one looks at the Companies Act, which tells you how a company executes documents. But the starting point is a requirement that it has to be done by deed. I'm just wondering whether your argument is proving rather a lot, because what you seem to be saying is that even where it's not done in accordance with section 44 at all, both parties are stopped from denying that. And then you just wonder, well, what's left of these requirements wherever a company is a party to something that is called a deed?
Well, I think what the way the estoppel works is that the landlord and the tenant respectively can't, in effect, deny that they're in that relationship, put it that way, because that really would be contrary to the estoppel of the type described in Woodfall.
But you seem to be saying they're stopped from denying that it's a deed, i.e. something which has been executed in accordance with these provisions.
So, yeah, I mean, essentially that is my submission, that the way the estoppel works, and I tried to explain this earlier, is that you've got you have a grant of a lease and then a grant of a sublease, and the parties to those two transactions are stopped from disputing each other's titles, if I can put it that way. They can't say that they didn't have a valid title, they didn't have good title, or that somehow the deed is ineffective to convey them the title that allows them to enjoy the land, because that would be contrary to the estoppels. And what happens is those instruments are registered at the land registry, a bit like the mortgage in the First National case, at which point the estoppels are fed and you then create the legal estates in land. And under I think it's section 58 of the Land Registration Act, once you're registered as the proprietor of the leasehold interests, you are deemed to be so.
And I mean, that's obviously true. Well, if you're on the register, you have title.
Yeah.
Forget about the validity of the earlier documents, subject to the possibility of rectification.
Yeah, yes, that's a different issue.
Well, it may not be a different issue. I mean, it may be that you can't really rely on feeding the estoppel in this context, because if it were otherwise possible to complain about the documents and the conditions for rectification were satisfied, then you'd come off the register anyway.
Well, that may be right. I mean, ultimately, the way you know, I'm so sorry, but I'm going to have to move on in a moment. My learned
Yes.
friend is, I'm sure, desperate to make his submissions. But the way it is expressed in, if one goes back to the House of Lords decision in Southern Pacific, which is at tab 38, page 899. Just has a look at the page 901, the quotation from Cuthbertson and Irving. Where a lessor without a legal estate or title demises to another, the parties are stopped from disputing the validity of the lease on that ground. In other words, a tenant cannot deny his landlord's title, nor can the lessor dispute the validity of the lease. And it's worded in a fairly general way that the lessor or the lessee can't dispute the validity of the lease. And that must be because of some operative estoppel. And so what one then has to think about is, well, in this case, and it's the way the judge approached it, if one goes to his judgment on this point, before I move on, if I just briefly go to that, it's at Core Bundle 142. At paragraph 399, the judge thought that Southbank's argument involved certain propositions at 1, 2, and 3. He seemed to accept proposition 2, engaged the estoppel, but then he said it involved no different proposition of law from that set out in paragraph 3991. And so it's difficult to see then why 3991 wouldn't also engage the estoppel. And then we get to Roman 3, which is the proposition that southbound is not bound by promises to pay rent. And it is said that that argument doesn't involve a challenge to Lodgeshine's title. But necessarily it does, because the rent is effectively derived for the entitlement to rent is derived from Lodgeshine's title. And that is exactly the Munro case that is referred to by the judge at 398. Could I move on? I'm so sorry.
Yeah, no, you're
my lady.
quite right. Mr.
I've got two matters to deal with, and I'll try and deal with it as quickly as possible before I hand over. The first of those is the question of the equitable lease, which is respondents ground 3, open brackets 6. So the question is whether the lease and underlease can take effect on equity. And the point taken against me is that there can be no equitable leases because an equitable interest will only be created if the court would grant specific performance. And South Bank says specific performance is not available in this particular case. And it gives 2 reasons. The first is one of unclean hands. That's paragraph 109 of its skeleton argument. Can I take you then to how this is dealt with in the pleadings? Core bundle, page 236. At the bottom of page 30, we have paragraph 19G. Where it is said that leases, if ineffective to dispose of legal estate, would take effect as equitable leases. And then the response to that is at page 306, paragraph 21L. It denies paragraph 19G, and what it does is repeats paragraphs 21A and B above. Pausing there, those paragraphs are to be found. I won't take you to it at page 304. They concern allegations of forgery. And then it repeats paragraphs 39 and 41 of the particulars of claim, which are to be found again for reference at page 195 and 200 of the bundle. And those paragraphs concern alleged dishonesty on the part of Mr. Conway and Galliard Hotels. And so the reasons ventured in the defence, or rather the reply, as justifying a refusal of specific performance have already been rejected by the judge on the facts, because the judge found there was no forgery, there was no dishonesty on the part of Mr. Conway. So the unclean hands issue then falls away on the pleadings. Then the other point raised against me as to why you won't get specific performance is that the contract was entered into, or at least the lease was entered into, in breach of trust. Because that doesn't work as regards the underlease, because Lodgeshine, as grantor of the underlease, is not a trustee of any property. Now, the judge has made no findings as to whether or not there's been a breach of trust. It's also not a point that is relied upon in the reply as a reason why specific performance would be refused. But in any event, what I would say is, and I'm trying to deal with this as quickly as I can. First of all, if there was a breach of trust, which I think in this situation must mean a breach of trust by Galliard Hotels in granting the lease, then it was one assented to by South Bank, because at the time it was entered into, all the parties had received or were aware of the advice from Mr. Phillips regarding the transaction and willingly entered into them in full knowledge of their terms and effect. South Bank relies on the Bilter case to say, well, there's a problem with attribution here because the individual responsible for assenting is Mr. Conway, and for these purposes you can't attribute his assent to South Bank. The Bilter case...
I don't pursue the Bilter.
Ah, he's not pursuing the Bilter point. Very good. Then the only other, I suppose, observation is that my learned friend yesterday took your lordships and my lady to some extracts in Snell at the very end of the authorities bundle in tab 57. Which contains the sentence in the second paragraph, where trustees make a contract in breach of trust, a court will not grant specific performance. And that then refers to and cites two cases, Turner and Harvey and Dunn and Flood. In my submission, the proposition in Snell is stated too broadly. Turner and Harvey, which is in the authorities bundle early on, tab 10, I think, the decision of the Lord Chancellor Eldon, dealt with a situation where the trustee had knowledge of the breach, essentially. And one can see at page 131 in the authorities bundle behind tab 10. I won't take you to it now because I just don't have time, I'm afraid. And then the other authority, Dunn and Flood, that's a slightly strange case in a way. It's difficult to discern exactly what the arguments were, but if I can just briefly take you to tab 13 in the bundle, the authority bundle, page 167. I would just draw attention to this. It was a case to do with some properties sold at auction, I think. And the buyers didn't wish to complete. Well, I just draw attention to the objections to completing in the second paragraph of 589. See, the purchaser's objections were 1, 2, and 3. And so it looks as though the case was argued on the basis that there was a defect in title that entitled the purchasers to rescind or avoid the transaction. And it's in that context that one gets observations, for example, of Lord Justice Fry, which are expressed quite broadly later on in the judgment at 1713, 173. So I think that's all I'm going to say on equitable leases. And then finally, I think the last point is an alteration of the register. So the relevant statutory provision is back in Authorities Volume 1, I think, tab 5, page 35. Which allows the court to make an order for alteration for certain purposes. And there's a special type of concept in this schedule called rectification. You'll see that from para 3.1. And that type of rectification is where you have an alteration that I've said so. It's paragraph 1. Rectification is an alteration which involves the correction of a mistake and prejudicially affects the title of the registered proprietor. And where you have that type of situation, then you can only make an alteration in the circumstances prescribed by 3.2. And if those circumstances don't pertain, then 3.3 applies, and you have to make the alteration. Now, if in this case the leases are incapable of, or were incapable when granted, of conveying an estate in land, or void for creating a legal estate in land, then the question is, do they take effect in equity? If so, the only sort of alteration that you could make would be to change legal leases and note them effectively as equitable leases against the relevant titles. But I would say that becomes then a question of rectification in the technical sense. And my learned friend, I think, ultimately, at the end of his submissions yesterday, said what he relies upon is the exception in paragraph 3.2, that there has been a lack of proper care in this particular case. Now, when one looks at the language of that and sees the reference to a lack of proper care, I would emphasise the word proper, and that connotes, in my respectful submission, that someone is kind of under a duty to do something, or at least ought to know better about something. So where a conveyancer, for example, misses something or fails to discharge his obligations properly, there'll be a lack of proper care. But in this case, the error, if I can put it that way, in execution only came about because Mr. Conway didn't know of the requirements under Section 44, so he had no reason to be put on inquiry when he came to executing the documents that something different should be done. It's difficult in those circumstances, I would suggest, to say that any of the parties acted with a lack of proper care. There is a question about priority of interests, which might possibly arise if there is an alteration of that type. That starts to get a bit more complicated because of paragraph 8 of Schedule 4 and a lot of the learning on how priorities of interests might be altered for the future under Schedule 4. I simply don't have time now to deal with that. But the reality is, if we get to that point, it's unlikely, I would say, that the issue of priorities is going to make much difference to anything. And just as a final observation, if let's suppose this would be a case of rectification in the technical sense under paragraph 3 of Schedule 4, and suppose that the court doesn't order rectification, well, one doesn't need to feel too bad for South Bank, because they would then get an indemnity under Schedule 8 of the Land Registration Act under, I think, paragraph 1(1)(b). So they would still get compensation for the non-correction of the error or the mistake. I'm sorry, that was a little bit rushed.
No, that's you've done well to squeeze it all in. So can we just take stock? Mr. McLaughlin, you're going to be addressing us on the other point on which Mr. Pugadiri had 3/4 of an hour. Just thinking ahead to tomorrow, you've got tomorrow morning. The timetable splits the time between you. I forget it in exactly what proportions. Is it at the moment a 50-50 split of 10:30 to 1?
I'm not immediately sure, but I'm being told.
Yes. So that would be an hour and a quarter each, would it? Mr. Trumpeter, in the end, you will be given the chance to respond on respondents' notice points, won't you? Not on anything else. No. Can we just think how long realistically each side is going to need for those points? Mr. Willan, how long do you think you need for your reply?
I would say an hour and a quarter.
Exactly the allocated time. I don't think that's unfair. I mean, there's a lot of ground to cover.
Yes. In a sense, I've got to deal with a reply on the appellant's notice and a response to new points on the respondent's notice, recognising, of course, I've already sort of preemptively responded on a lot of it. But I will try and make it shorter if I can, but it certainly won't go over an hour and a quarter.
Fine. Mr. Trumpeter, I'm conscious we've already had a long day. Now, Mr. McLaughlin could start for a quarter of an hour now. My inclination is that he ought overall to have 3/4 of an hour.
Agreed.
If we started at 10 o'clock tomorrow, then we would need to shave a quarter of an hour off your reply time to make sure that we finish by 1 o'clock.
I think that will be fine. I doubt, given that I have a limited right of reply in relation to respondents' points,
Yes.
I would be disappointed if I needed more than an hour.
And of course, if you turn out to be shorter, we will not complain. So on that basis, I think we won't, Ms. McLaughlin, start with you tonight.
Very good.
But we'll sit at 10 tomorrow and give you the same 3/4 of an hour that Mr. Borcadieri had.
Very grateful.
All rise if able.